That's it. Fine. Today, yesterday we discussed Article 75. Yeah. Today we shall discuss Attorney General. Because a new Attorney General has been appointed, we have to discuss about the issue of Attorney General becomes important. So, see, for example, here you have to understand two things. One is Attorney General for the Union Government. The same way, there is something called as some another office called as Advocate General for the state. See, these two offices you have to understand at the first instance. Okay, who is Attorney General and how is he appointed, who appoints him, what are his functions? These are the important things which you have to understand. Let us see how it works. See, basically, Attorney General is the Chief Law Officer for the Government of India, to who the Government of India goes for advice with respect to any of the legal issues concerning the government, and he is the one who appears on behalf of the Government of India before the Supreme Court, and he will be assisted by various solicitors generals. Right, now, let us try to understand these two offices. See here, this will be the office of the Attorney General. See, Attorney General is provided for in Article 76 of the Constitution. Article 76 of the Constitution deals with the provisions relating to Attorney General. Right, see, first of all, Attorney General is the highest law officer of the Government of India. He is appointed by the President. Now, this is a difference. This could be a potential prelims question. Because why it becomes an important question is because what could be the question where you can falter is, be careful about this particular word. Supposing if the statement is given, the Attorney General of India is appointed by the President by a warrant under the hand and seal of the President, it is wrong. Right? Attorney General is not appointed by the President by a warrant under his hand and seal. He is just appointed. Now, what is the difference between being appointed by and being appointed by a warrant under the hand and seal? Generally, in the Indian Constitution, any office that is granted independence, any office that is independent of the executive and legislature, one of the foremost conditions with respect to appointment is that office being appointed by the President by a warrant under his hand and seal. Generally, if you look at the appointment of judges of Supreme Court, judges of High Court, Comptroller and Auditor General of India, you will find this term, being appointed by a warrant under the hand and seal of the President. But Attorney General is not appointed by a warrant under the hand and seal of the President, but he is just appointed by the President of India. Clear? Okay, why am I talking about this very particularly? Is because the Attorney General is a person, or any person to be appointed as an Attorney General must be qualified to be appointed as a judge of Supreme Court. This is the deceiving point. Sometimes when we come across this kind of a statement or this kind of a qualificational requirement, there is a possibility that you may get carried away by this. He must be qualified to be appointed as a judge of Supreme Court, but he is appointed by the president, not by a warrant under the hand and seal of the president. Point number 1 to be noted. Similarly, another point. See, coming to the duties of the Attorney General. The Attorney General, the Constitution does not prescribe any duties or functions to Attorney General. But generally, the Attorney General will be giving advice to the Government of India on all the legal matters that are referred to him. Apart from that, he will perform these two functions. To perform such other functions of legal character as may be assigned to him by the President. Fine. What do you mean by this? Very simple. Any matter relating to the legalities of the issues. To put in simple words, any case that is filed against the Government of India. See, if you look at Article 300 of the Constitution, it says the state can be sued and the state can sue. Meaning, the state can file a suit against anybody. Same way, anybody can file a suit against the state as well. When a suit is filed by the state, or if a suit is filed against the state, such matters are handled, or one who appears on behalf of the Government of India will be the Attorney General. Apart from that, in case of any legal opinion, it could be even for a bill. Right? It could be even for a bill, because sometimes we have something called as there are three important reports in India. One is Environmental Impact Assessment Report, EIA. The second is Judicial Impact Assessment. The third is Social Impact Assessment. With respect to Judicial Impact Assessment, what do you mean by this? When a bill is passed or when a policy is being made by the Government of India or any action to be taken by the government, what would be the judicial impact upon that act? Whether there is a possibility of that particular action being challenged before the court of law. If so, what could be the grounds? If such grounds are there, what could be the defense? Or whether that particular portion of the law or the policy can be modified in order to avoid such litigations. That is called as Judicial Impact Assessment. With regard to this also, the Government of India can consult the Attorney General of India. Fine. What is the need for the Judicial Impact Assessment? Now, according to National Litigation Policy, according to National Litigation Policy, 85% of the cases that are pending before the courts of law in India, the litigant is the state. Right? Litigant is or put in other words, the most primary litigant in Indian courts are the state. That is because in all the criminal cases, state is a prosecutor. And in several other cases, there can be cases against suits filed against the. Therefore, the most important litigant in any case in Indian courts, state is a litigant. Therefore, the National Litigation Policy has been formulated to ensure that the state will be a responsible litigant. In order to ensure that the state is a responsible litigant, as well as to avoid state being a litigant, so that the number of cases pending before the courts of law is increasing, the concept of judicial impact assessment was proposed. And when the judicial impact assessment report is being prepared, the Advocate General plays an important, Attorney General with respect to Union of India and Advocate General in respect of states will play an important role. That is why we say such other functions. He will advise the government in legal matters, and such other legal functions, whatever the government of India or the President of India on the advice of the Council of Ministers refer to Attorney General, the Attorney General will give his opinion. Similarly, he will discharge such other functions by the Constitution or any other enactment. That's what Article 76, Clause 2 says. Clear? Fine. Another important aspect. See, look here. The Attorney General appears on behalf of the Government of India in the Supreme Court. He may also be required to appear on behalf of the Government of India in any High Court. All right, fine. Now, look at this. Since the number of cases in the Government of India as his party is very large, he cannot appear in all cases. Hence, he will be assisted by Solicitor Generals. The Solicitor General is appointed to assist the Attorney General, and additional Solicitor General of India are also appointed to assist the Solicitor Generals, and Solicitor General advises the government on legal matters and appear before the courts on behalf of the government. So, while Attorney General and Advocate General are constitutional officers, Solicitor General is a statutory office. All right. So this can be a question statement. This can be a statement that can be asked in the question also. So there can be a comparison between Attorney General and Advocate General, or there can be a comparison between Attorney General and Solicitor General. Fine. So far, so good. Another important point to be noted with respect to Attorney General is his rights. Right? His rights. It's very important. Look at these 2 points. He is granted audience in all courts in the territory of India. In any case, if he wants to sit as an audience while the trial before any court in the any court in the territory of India, he shall be having the right to audience in all courts. Most important is the second point. He can speak and take part in the proceedings of Lok Sabha, Rajya Sabha, or any of the joint sittings of the houses. See, he can take part and speak in the proceedings of Lok Sabha, Rajya Sabha, and any joint sitting of the houses, also before any committee of the Parliament. Article 88 of the Constitution grants this power to Attorney General. However, he will not be, because Article 88 is dealing with, Article 88 is a provision of the Constitution that deals with the power of the members of the Parliament to take part in the procedures of the Houses of the Parliament, as well as the right to vote. According to Article 88, Attorney General is having the right to partake in the procedures of the Lok Sabha, Rajya Sabha, or any joint sitting of both the houses and any committee of the Parliament. Any committee means blanket, all committees, including the department related standing committees. Now, the point here is he is the only officer who is allowed by the Constitution to participate in the meetings of the Parliament, but he does not have the right to vote. Now, here is again a catch. There are 2 officers of the Constitution of India who are not members of either houses of the Parliament, but are permitted to take part in the procedures and speak. One is the Attorney General. The 2 officers who have the right to partake in the procedures and speak in the Parliament. One is Attorney General The second is CAGI. The CAGI is a parliamentary officer. He conducts the audit of the accounts of the union government, state governments, and select PSUs which are referred to him by the President of India under the Indian Audit Order of 1931. The parliament can call him to explain certain portions of his report. Therefore, he will have the right to speak and partake in the procedures, but does not have the right to vote. The difference here is for Attorney General, the Constitution Article 88 itself grants this right. But for CAGI, the Constitution does not provide for this right, but it flows out of the CAGI Duties, Powers and Functions Act. Because the CAGI is the parliamentary officer, and on behalf of the parliament only he conducts the audit. Because in every parliamentary democracy, or in any democracy for that matter, the principle is the executive shall demand and legislature shall sanction. Because the legislature sanctions the expenditures, it is the legislature which must be informed about how the money was spent, whether the money was spent on right lines, whether the money was spent on for the head for which it was allocated, whether the money was spent within the limits, whether the money was spent by the appropriate authority, whether the money was spent with proper application of the canons of financial propriety. All these things will be done by the CAGI, and for that matter, the CAGI also has the power to partake in the proceedings of the House and speak in the Parliament. But Constitution doesn't provide for him this right. Whereas for Attorney General, Article 88 of the Constitution itself expressly providing for the right of the Attorney General to take part in the proceedings of the Parliament, joint sittings of the houses of the Parliament and committees of the Parliament, and to speak but not to vote. So these are the important points that can be asked in the Prelims. So you can compare Attorney General and CAGI with respect to this part. Clear? Fine. Now, similarly, there is another office, or a similar office is found in the state, who is the Advocate General. The Constitution, Article 165, provides for the office of the Advocate General of India. Right? Here, like the President, here the Advocate General is appointed by the Governor and will hold office during the pleasure of the Governor. Same way, Attorney General will hold office during the pleasure of the President. To be appointed as Advocate General, a person must be qualified to be appointed as a Judge of High Court. For Advocate General, now let us, so here also, see, look here, Article 177. Article 177 grants the right of Advocate General to partake and speak in the proceedings of the state legislature, but not with the. However, let us try to compare the Advocate General and Attorney General so that we will understand what it is. So look here, you can understand this. Attorney General role is a law officer of union. Advocate General is a law officer of state. What are the duties? To give advice to union government upon legal matters and perform other duties of legal character with respect to union government. Advocate General does the same with respect to states. So tenure during the pleasure of the President, Attorney General. For Advocate General during the pleasure of the Governor. Qualification, Attorney General to be appointed as a Judge of Supreme Court. Advocate General qualified to be appointed as a Judge of High Court. Salary, it is fixed by the President, here fixed by the Governor. This sort of salary is sometimes referred to as retainer. He is paid a consolidated sum of money called retainer. To retain him, it is called as retainer. Now, what is the role with respect to legislature? They can partake in the proceedings of the Parliament, speak but not vote. Same way in the state legislature. This is the one important difference. While Attorney General enjoys the right to audience in all courts within the territory of India, Advocate General does not have this right. This is important. This can be again a misleading statement. If the statement is asked, both Advocate General and Attorney General enjoy the right to audience in all courts within the, while the Attorney General of India has the right to audience in all courts within the territory of India, the Advocate General will have the right to audience in all courts within the territory of a state for which he is appointed as Advocate General. That statement is wrong. Clear? Fine. Now this is the ideas relating to Attorney General. A new Attorney General has been appointed. So take care of that. Fine. Coming to the next issue. Now this is becoming an important issue here. Governor's power to assent to bills. Governor's power to assent to bills. Now, under the Constitution of India, when a bill is passed in the Houses, first of all, let us discuss before we go to assent to the power of the governor to assent to bills, we'll first understand the power of the president to assent to bills and then compare it with the power of the governor so that we will be able to understand it much more clearly. This is the power of the president to assent to bills. Article 111. According to, see, in India, whether it is parliament or state legislature, whatever it is, how is a law enacted? Basically, in the legislature, bills are introduced. The bills will be introduced in the Houses of the Parliament. The Houses of the Parliament will discuss the bills, debate upon the timing of the bill, objective of the bill, principles behind the bill, and every provision of the bill in detail. Sometimes the bills can be referred to select committees or joint parliamentary committees. Today, we have something called as department-related standing committees, which are the a kind of a permanent standing committees, means permanent committees. They are always there. These committees will go through the bills and then the bills will be passed by the Houses of the Parliament. And once the bill is passed by the Houses of the Parliament, Article 111 makes it very clear that such bills have to be presented to the President for his assent. After the President grants his assent, and after the President grants his assent, the bill will become an act. Right? The bill, after being passed by the Parliament, will be presented to the President for his assent. Right? After the assent of the President, it becomes an act. After the rules and regulations, which are sometimes called as subordinate legislations in India, are notified or formulated for the implementation of the bill, and the bill being notified in the Government Gazette, the act becomes, the act comes into force. The act comes into force. This was once asked in the prelims. A bill, just because it has been assented to by the president, will not come into force. The bill will come into force. Only the bill will be passed by the parliament, presented to the president for assent, the president granting his assent, then the rules to implement the bill is passed. After the rules being passed, it will be notified in the Gazette of the government, and after the government Gazette notification is coming, the act will be coming into force. Now, in this process, what do you mean by this assent? And what happens to the bill when the bill is given to the president for his assent? When the bill is presented to the president for his assent, what happens is the president has certain options to do. What are the options available to the president when it comes to the bill that is presented to him for his assent? First thing, he can declare that he gives assent to the bill. Right? The president can declare that he gives assent to the bill. Once the president gives his assent, the bill becomes a law. Second, he can declare that he withholds his assent. It means the president has vetoed the bill and the bill is dead and buried. This is what you mean by absolute veto. The president declares that I withhold the assent. Right? I withhold the assent. I don't want to give the assent. That is what is called as. Remember, the president withholds his assent. That is called as absolute veto. Fine. The third option available to him is he can return the bill to the House for reconsideration with certain recommendations for amendment, or generally without any recommendation for amendment. Anyway, he can give his assent. Sorry, either way he can return the bill to the houses. If in this case, what is happening in the third case? The president is saying, I am withholding the assent to bill in this form. Kindly understand this very clearly. When the president is returning the bill, what does this mean? The president says, I am withholding the assent for this bill if the bill is in this format. I want certain amendments to be done, or I want the bill to be reconsidered by the houses. Until then, I don't want to give assent. I'm withholding my assent, meaning the president is vetoing the bill at that stage. So, when the bill is returned, Article 111 says, if the president returns a bill to the House after being presented to him for his assent, the houses of the parliament has to reconsider the bill along with the messages that was sent by the president, along with the recommendations, if any, that was made by the president. However, if the House, it is a discretion of the houses to either accept the recommendations of the president or not to accept the recommendations of the president. Supposing if the bill, if the houses believe that the bill in its original form is all right and the president's recommendations are not acceptable, then they have to discuss it, record the reasons as to why it is not, why the houses reject the president's recommendations, and then pass the bill again. After being passed by the houses for the second time, again it will be presented to the president. Now the president has no other go but only to assent to the bill. Now, what do you mean by this? Here, at the first instance, president withheld his assent, which means he has vetoed the bill. But the bill was passed again. Now the president cannot withhold his assent but has to give his assent, which means the veto that was exercised by the president has been overridden by the parliament by passing the bill again. Clear? Now, here Article 111 does not prescribe any special majority for the bill to be passed in the second instance after being returned by the president, which means the bill can be passed by the simple majority. In turn, what does this mean? When the president withholds the assent to the bill in its format and returns it to the houses of the parliament, the houses consider the messages of the president and pass the bill again by simple majority. Now the president has to give the assent, which means the presidential veto is overridden by the houses by a simple majority, and such veto is called as suspense veto. Clear? Clear? So far, so good. Supposing if the constitution recommended for a special majority, then it will be called as qualified veto. So when a bill is presented to the president after being passed by the House of the Parliament for the assent of the president has three options. According to Article 111, the president has three options. Apart from these three options, the president also has one more option, which is implied power. What is that implied power? After bill is passed by House of the Parliament, it is presented to the president for his assent. When a bill is presented to the president may declare that he gives his assent, declare that he withholds his assent, that is absolutely vetoing it, return the bill, that is suspense veto. The fourth is the president will do neither of the three. He will not declare that he gives assent. He will not declare that he is withholding assent. He will not return the bill. He will withhold the bill itself. Right? Withhold the bill itself without taking or without expressing to take any action. If the president is holding it beyond a point in time, the bill may lose its relevance, or the bill may, the issue which the bill was addressing could have become diluted, and after considerable time being gone, the bill will become useless. Such veto is called as pocket veto. Pocket veto is not given in the constitution, but it is an implied power that is assumed by the president, because the constitution does not prescribe any specific time limit within which the president has to declare his decision upon any bill. Hence, it is called as pocket veto. The president is sitting on the bill. It's otherwise called as president sitting on the bill. It's otherwise called as president has pocketed the bill. Got it? Fine. This is the position with respect to president. So, okay, fine. What is the position of a bill when it comes to the governor? See, this was actually asked in the mains 2005. Write a short note on pocket veto. 2009 it was asked. Veto power of the Indian president is a combination of absolute suspension and pocket veto. Comment. 2005. Right. So this is a very important question. Now let us try to understand what is the position of the governor here. What is the position of the bills with respect to state legislature when the bill is passed by the passed by the state legislature and presented to the governor for his assent? What happens? What are the powers the governor has? See, here again, see, assent to bills and veto, the power of the governor. Like the Union Parliament, any bill passed by the state legislature needs to be presented to the governor for his assent. Only upon governor giving his assent, the bill will become a law, and after the rules are made and the state gazette and the bill along with the rules are notified in the state gazette, the bill will come into force. Same procedure. Now, when a bill is presented to the governor for his assent, what are the options available to the governor? The same three options: give his assent, or withhold his assent, absolute veto, or return it for reconsideration with or without messages. The fourth option available to him is to reserve the bill for the consideration of the president. Right? To reserve the bill for the consideration of the president. This is given in Article 200. Article 200 of the Constitution provides for this power to the governor. Okay. What will happen to the bill if the governor reserves the bill for the consideration of the president? That is being dealt with by Article 201. Bills reserved for the consideration of the president. When a bill is reserved for the consideration is presented to the president, what are the options available to him? Number one, he may declare that he gives his assent. Then it becomes a law as usual. He may declare that he withholds his assent, which means absolutely veto, the bill is dead. Third, if it is not a money bill, see, money bill cannot be returned. Why money bill cannot be returned? I shall explain to you later. If it is not a money bill, the president may direct the governor to return the bill for reconsideration of the House. While returning, the president may make certain recommendations or may not make recommendations. However, he can return the bill. Once the president has directed the governor to return the bill for reconsideration of the House, the governor returns the bill to the House. Here, no doubt, here it is very important. When a bill reserved by the governor for the consideration of the president is returned by the president for the reconsideration of the houses of the state legislature, the state legislatures must reconsider the bill and pass the bill again before 6 months. Kindly noted, for the Union Parliament, when the bill is returned, there is no time frame fixed for the houses of the Parliament. Whereas for the state legislature, if the bill passed by a state legislature is reserved by the governor for the consideration of the president, and president upon considering it finds it to be reconsidered and returns the bill, then the houses of the state legislature have to reconsider and pass the bill before the expiry of 6 months from the date on which the House received it. Condition number 1. In the Union Parliament, if the bills are reconsidered and again presented to the president, the president has no other go but only to give his no veto power is available. Whereas with respect to state bills, the president still have the power to reject. The president will enjoy absolute veto upon a state bill reserved for his consideration, and he returning it, and even after the state legislatures reconsidering and passing the bill and presented to him again, still he can absolutely veto the bill. These two conditions are important. These are possible tricky areas where the questions can be raised. Fine. Now, assent to bills has been a very important thing. This Article 200 and Article 201. These are very much in news with respect to the governor of Tamil Nadu, governor of Telangana, and Telangana government has moved the court also. So, make note of it. This is very important. Now, coming back to one more thing, I told you non-money bill. When it comes to suspensive veto or returning the bill for reconsideration, the president and governor can only return a bill which is not a money bill. Why a money bill cannot be returned? An important question. Why a money bill cannot be returned? Money bills cannot be returned because with respect to Union Parliament, a money bill is introduced into the Parliament only upon the previous or prior recommendation of the president only. So whatever clarifications or amendments or advisors or any changes, the president has to do it then and there itself. The president has no other go. There itself he has to do. With respect to state, the governor has to do it then and there itself. That's the reason why a money bill cannot be returned. Otherwise, money bill can also be vetoed. When a money bill is presented to the president after being passed by the Lok Sabha, the president has the power to absolutely veto it. He can declare that he withholds his assent. All right? Fine. I hope it's clear to you, right? Okay. And make note of it because of the Tamil Nadu issue and Telangana issue and several other states. This has been very much in news. Fine. So far, so good. Let us try to understand the next issue. These two issues will come a little later. Wow. Now, let us take up right to freedom of religion as well as president and governor. We'll group them together, right? Fundamental rights and other aspects group. After that, we'll come to other issues. Again, the same issue relating to president and governor's power to right of addressing the houses of the parliament, right? We shall discuss that first. We'll take up this issue, the 9th issue. If you have the book with you, you can see that as well. So this power of the president or right of the president to address the houses of the parliament is one of the very important powers, as well as in the book, if you have the book, you can see this in the 11th chapter. It's there. I've given it here. See, Article 86 and 87 of the Constitution. That is exactly what is the controversy or what appeared in the news. Fine. See, with respect to President, Article 87. With respect to Governor, Article 176. Article 86 provides for the right of the President to address the houses of the Parliament and send messages to the houses. The President can address the houses either separately or jointly, and for the purpose, he can require the attendance of the members. Similarly, the President has the right to send messages also. And Article 86, this is very important. This has been asked in the prelims also. The first session of the Lok Sabha in case of Union Parliament and the first session of the Parliament every year begins with the President's address. In Union government, we call it as President's address. In state government, we call it as Governor's address. See, President's address and Governor's address are very, very important, right? For President's address and Governor's address are very, very important, especially make note of them with respect to mains for the governance paper also. Paper 2 for the governance chapter also. Because President's address and Governor's address are considered to be one of the important tools of legislative control over administration. Right? Legislative control over administration is an important aspect of a parliamentary democracy. So keep that in your mind, mark it for later reference. Now coming to Governor's address and President's address. So the President can address the houses either jointly or separately. He can send messages. And every year, the first session of the houses begin with President's address. In the Indian Parliament system, we have 3 sessions. The budget session, which is the first session of the year. Second is the monsoon session. And third is the winter session. The budget session is the longest session and winter session is the shortest session. This was asked in the prelims. So the first session is budget session. The budget session of every year begins with the President's address. It is a constitutional requirement. In case of the state, right, in case of the state, the budget session will be beginning with the Governor's address only. It is a constitutional condition. Okay. What do you mean by this Governor's address? Or what do you mean by this President's address? The Governor's address or President's address is a document that is prepared by the Union government in case of President's address and state government in respect of Governor's address, which the President and Governor will respectively read on the floor of the House. What is this? What will be the content of that? Right? What will be the content of that? And why should the President read the document that is prepared by the government? If it is President's address, President has to come and address. If it is Governor's address, Governor has to come and address. Why it is required for the government to prepare it? It's a very important question. See, look. As far as the Constitution of India is concerned, it says the President shall, Article 74 and Article 163. Article 74 for President and Article 163 for the Governor. They say there shall be a Council of Ministers, 164 for State. There shall be a Council of Ministers to aid and advise the President, who shall exercise his functions in accordance with such advice given tendered to him by the Council of Ministers. There are certain other conditions or there are certain other circumstances when the President may act without the advice of the Council of Ministers, which the Constitution has given the conditions. Where all the President can act without the advice of the Council of Ministers, the Constitution has mentioned. In the book, I have given you about 20 different cases where circumstances in which the president will act without the advice of the Council of Ministers. I'll show you where it is. You can refer it. Article 53 of the Constitution says the executive power of the Union shall be vested in the office of the President, who shall exercise it either directly or through officers subordinate to him. What do you mean by directly? Direct, the expression directly in the Constitution, Article 53 says the President can exercise his powers without the aid and advice of Council of Ministers. It does not mean he can apply his personal discretion, but he has to comply with Constitution. So, circumstances in which the President will act without advice of Council of Ministers, that is, he will exercise his powers directly. Such circumstances can be to comply with the conditions of Constitution or apply his judgment to satisfy the requirements of the Constitution, not his personal discretion. Apply his judgment to protect, preserve, and defend the Constitution. And in his personal capacity, for example, if the President wants to go on leave, right? If the President wants to resign, he cannot go and seek the aid and advice of the Council of Ministers. So such things are called as, so this was once asked in the mains as well. So there are about 20 different circumstances in which the President will act without the advice of Council of Ministers, that you can see. One of them is, right, I hope you understand what is exercising directly. So, only if these four conditions are applicable, or if the Constitution expressly provides that the President shall act even without the advice of the Council of Ministers, then the President can act without the aid and advice of Council of Ministers. If the Constitution is silent, or if the Constitution does not prescribe any such condition, the President has to exercise his power only with the aid and advice of Council of Ministers. The same logic, the same thing, the same condition applies to the governor also, because similar is given in the state provisions of Constitution relating to state as well. Now, when it comes to addressing of the Parliament or sending messages, the Constitution does not prescribe any conditions. Right? For the President or the Governor, the Constitution does not prescribe any conditions, which means the President's address or the messages what the President wants to send to the Houses of the Parliament will have to be based on the aid and advice of. That is the reason why the President's address is prepared by the government. Okay, what will be the content in the President's address? The President's address or the Governor's address in case of state will have two important parts. One is the achievements of the government in the past year. The second will be the proposals for the next year. Right? The achievements of the last year and proposals for the next year. Two parts will be there. In this regard, the President will say that my government, because it is his government. All the executive powers are vested in the President, and the Council of Ministers are only for aid and advise the President. So basically, the government is that of the President. So the President will say what my government has achieved last year or what we have achieved through the Council of Ministers and the civil servants, what we are going to achieve in the next year. So this is what will be prepared. he will read. So far, so good. But the issue was, the president has to exercise these powers with the aid and advice of the Council of Ministers. Since Constitution does not mention any condition, hence the address is prepared by the government. The president ceremonially reads that out. So far, so good. But here the question is whether the president has the right to deviate from the text or is bound to read it verbatim. Can he deviate? Right? This becomes an important question. Way back in 1996, in the Tamil Nadu Legislative Assembly, like the situation what prevails today, there was a tussle between the chief minister and the governor. The state government and governor were not in a sort of a harmonious relationship, and the governor was confronting the state government, and in turn the state government was confronting the government, and chief minister and the governor did not have a proper relationship. So it actually became a issue. So the then governor, Dr. Channa Reddy, when he addressed when he read the address of, the governor's address in the budget session of 1996, where all they have mentioned as my government, the governor read it as this government. At that time itself, it became an important question. What does this mean? The governor is disowning the government. The governor is, and it is going on record on the floor of the Legislative Assembly. Is it appropriate for the governor to deviate this way? And later on, when Dr. K.R. Narayanan was the President of India, he took the privilege of deviating from the president's address that was prepared by the government. He went on to express his own opinions and comments. For instance, the Council of Ministers have prepared the president's address in which they mark some issue, say X, as the achievement of the past year. The president will read it and he will say that though it is an achievement, I feel it would have been done in a better way, this way. Some suggestions he was telling. This actually became handy for the opposition parties. I told you the president's address or the governor's address in case of state is a tool of parliamentary control over executive. After the president's address is over, there will be few days allocated for debating the president's address, and after the debates are over, there will be a motion to thank the President of India or the motion to thank the governor in case of state will have to be passed. Generally, these are ceremonial, and generally there won't be any, though the members of the parliament are allowed to ventilate the grievances, take up anything for the debate and embarrass the government, everything is fine, agreed, point allowed. But after that, they will ceremonially, one of the members will move the motion to thank the president, and the motion to thank the president will be passed, will be carried. That is why we say it is a tool of legislative control over the. But this time, until now, since the commencement of the Constitution, only in 3 instances, the motion to thank the president was amended. Right? Motion to thank the president was amended. Only 3 instances. See, these are certain constitutional conventions which have to be upheld, right? Which have to be upheld, and no deviation is permitted, and any such deviation is considered to be, right? Any such deviation is considered to be, what to say? It is something that is not well taken by the government, and it is something, an erosion of the confidence of the House upon the government. It's more of a moral ground. It's more of a moral ground. So generally, President's address is, no government wants any hiccup in that, and they want the President's address or Governor's address to be till the motion, beginning of the President's address till the motion to thank the President. Until then, they want things to be smooth. But what happened with Dr. K. Narayan was making comments, and that gave specific points to the opposition party, and the government was embarrassed. And after in 2014, when the present government, NDA government in their previous term, they asked for this black money and all. When there was no mention about the black money, the opposition wanted the motion to thank the President to be amended, and that was why the Justice Shah Committee and the other Shah Committee was all. That is a history. Just 3 times President's address has been, the motion to thank the President has been amended. So to that extent, it is important. Now the question here is, can the President or the Governor deviate? In this year, the Governor walked out. This looked at as a very serious issue. That is why we are discussing it here. Now, can the President deviate? Can the Governor deviate from the address that has been prepared by the government of the state or government of India? It is now settled that President can deviate. The President can deviate because the President can deviate. Because he being the first citizen of the country, and he being the first citizen of the country, he also has his right to express his views. So he can deviate. Nothing wrong if he deviates. Why to unnecessarily withhold that right to the President? So they can deviate. But generally, technically, yes, they can deviate. But going by the constitutional morality, should the President and Governor deviate? Should the President and Governor embarrass the government? Because they are the de jure authority. They are the appointed, they are the de jure authority, whereas the Council of Ministers are de facto. In a healthy democracy, on the moral grounds, it is not acceptable. However, technically, yes. Then the second issue, another issue comes as the President has the right to send messages. That's fine. But he has to send the messages only with the aid and advice of the Council of Ministers. What in case the message what the President wants to send to the Houses of the Parliament is not acceptable to the ministers? Supposing the President wants to send, take the case of Tamil Nadu, the Governor wants to send a message to the Houses of Legislature, the Legislative Assembly of Tamil Nadu. The Chief Minister does not like it. What will happen? The President has the right to send messages, but such power has to be exercised only with the aid and advice of the Council of Ministers. When the President seeks the advice of the Council of Ministers, headed by the Chief Minister, with respect to a message which he wants to send to Legislative Assembly, but the Council of Ministers are not convinced with the message and they don't want the government to send that message to house, what will happen? This will be a deadlock. This will result in a deadlock. So for example, for instance, the resolution passed by the State Legislative Assembly in Tamil Nadu against the governor, in which the finance minister of the state exposed so though it is a statement that it is available, it's available on the Governor's Salaries Allowances Act is there. There for every state, the heads of expenditure to governor and what is the amount of money to be spent, everything is very much available. You can you can download it from the internet and you can get to know. There are every heads. How many vehicles should be given, how the governor can travel, what will be the travel allowance, where he can go for air travel, where he can go for train travel. In case of train travel, whether he has a right to book a saloon, and who all he can take along with him, maximum of 4 persons, and when he can take his spouse, when not, and how much is for his household expense. Everything is there. The problem is, though they are charged in the consolidated fund, during the discussion upon the resolution against the governor, the finance minister of the Tamil Nadu state had highlighted certain expenses which amounts to have, or instead he has openly called it as misappropriation. Now this is a deadlock. So we cannot permit such high constitutional office to be brought to this kind of a political debate. Hence, both the governor as well as the council of ministers have to have certain amount of political maturity to uphold the constitution rather than simply taking things for granted. Clear? So far so good. So this is a important aspect here. Make note of it. This can be asked in the mains also. It's more to be asked in the mains as well. Okay, now this Madhya Pradesh Freedom of Religion Act. Let us try to understand what it is. See, Madhya Pradesh is passing a law, Freedom of Religion Act of 2021, which is relating to this one. See, it's a kind of a anti-conversion law. See, this is one of the very, very important issues that have been there ever since independence, ever since the commencement of this constitution. If you look at the Freedom of Religion Act, or right to freedom of religion that has been provided for in the Constitution of India, in the Constitution of India, we have the right to freedom of religion being guaranteed by Articles 25, 26, 27 and 28. Right? Here, Article 25 of the Constitution guarantees the right to conscience, right to profess, practice and propagate a religion of one's choice. Of all, the most controversial aspect relating to this news is the right to propagate. And this right to propagate is the fundamental issue. Propagate means to communicate a person's beliefs to another or to expose the tenets of that faith to someone who is ready to accept, or with someone else. This is what you mean by right to propagate. But here the question is, does the right to propagate includes the right to proselytize, meaning the right to convert? Is the right to propagate a right to proselytize? Was a question. Here the issue is, whatever you say, right to propagate, there are two views. The right to propagate and right to conscience. These are the two things that are in conflict. According to Constitution of India, the right to conscience is man to God relationship, it is absolute. It has to be read in conscience as the preamble. The preamble says there is liberty of thought, expression, belief, faith and worship. So liberty of thought and expression are fundamental for the belief, and belief will be fundamental for faith, and faith will be fundamental for worship. This is order. So what is thought? Thought is something that is happening in the minds of a person which cannot be regulated or restricted. It's impossible. And it can be regulated, it can be influenced. It can be definitely influenced. But what the preamble of the Constitution of India guarantees to citizens of India is the right to unfettered thought. So do I have the right to think against the government of India, against sovereignty of India? Yes, you can. Unless and otherwise your thoughts are being expressed as actions, and as long as the thoughts are within you, nobody knows it, and you have the right to. Because there should be a debate. There should be a debate. What is thought? Thoughts, what is the purpose of right to liberty of thought? The liberty of thought, the purpose of liberty of thought is to enable every individual to involve himself or herself into a debate within herself before they arrive at any conclusion, before they make any decision. That is the purpose of liberty of thought. Therefore, the thought must be unfettered, uninfluenced. Clear? Only based on this right to unfettered liberty of thought, the right to conscience will come. Now, I follow a particular faith, or I belong to a category of people who are, say, so-called atheist. I don't believe in God. I am not a believer. Can I propagate my ideas to you? Can I? I can. Now, what will you do? Because I propagate, you will also apply your thought. Then after that you can say, sir, you be with your atheism, I be with my theism, I be with my faith. Or you may say this or that, whatever it is. So it is right to conscience, which is man to God relationship, absolute and not restricted. What in case I purposefully come to you with an idea of converting you from the faith of religion, what you have, to another religion, or to make you an atheist? Will it fall under the idea of propagate? Will it fall under the right to propagate is the question. Will it fall under that? Can we permit it is a question. Now, how can it be possible? This is the issue. Not only now. Way back in 1970s, see, this is the most important, Father Stanislaus case. Reverend Father Stanislaus case. Then itself, it's again Madhya Pradesh. Father Stanislaus versus State of Madhya Pradesh, 1977. In 1975, Madhya Pradesh enacted a law. It was an anti-conversion bill. The law said, right to propagate, guaranteed by Article 25, Clause 1, does not include the right to proselytize, and therefore, any conversion from one religion to another religion by force or allurement, a conversion by force or allurement is prohibited. Subsequently, state of Orissa enacted another law which prevented conversion by force or inducement. Subsequently, in 1975, in the Union Parliament, a private member bill was introduced, which is an anti-conversion bill. Sometimes it is called as Tyagi bill. It was at that point in time, Reverend Father Stanislaus filed a case in the Supreme Court against the state of Madhya Pradesh, which included Orissa as well. And his prayer was, the law enacted by Madhya Pradesh, as well as the state of Orissa, as well as the bill being introduced in the parliament, the intention of the government of India, everything, all are against Article 25, Clause 1, and it is an infringement upon the fundamental right to freedom of religion. Because these acts, as well as the bill, forget about the bill, these acts are taking away the right to propagate. In that case, the Supreme Court ruled that what is being conferred by Article 25, Clause 1 is the right to propagate, which is to communicate your faith to others, and it does not include the right to convert. Right? The court took that stand because it said the law of the Madhya Pradesh or Orissa government, they say conversion by force or allurement is prohibited. Voluntary conversion is right to conscience. That cannot be converted. That cannot be. Nobody can stop it. Secondly, it is not against the Christians. Reverend Father Stanislas said it is against, this law is against Christians. Then the court said, no, it cannot be construed as a law that is placed against any one religion, because the law says conversion from one religion to another religion. It does not mention that conversion from majority religion to minority religion, or from minority religion to whatever it is. If there is a conversion, and if that conversion was by force or allurement or inducement, then that conversion, irrespective of from which religion to which religion, is prohibited. Therefore, the law is upheld. So, this is a very old case and a ever existing issue. Now, the same issue is cropping up today. That's the same issue cropping up today. The same concept. Whether the, so how will you, now the question here is, how will you prove that it is not by force, but it is not, it is not by, the most important question here is, what is a conversion by force or what is a conversion by allurement cannot be, what is by allurement or what is by force cannot be easily made up. Can you ever identify? That is a challenge. The challenge of, even though you can have, right, even though you can have a law to declare anything of this sort as prohibited, or it doesn't fall within the purview of 25, whatever it is. But the challenge is, how will you actually identify whether a particular conversion is by force or allurement, right? But this is unacceptable. Give a declaration before a district magistrate and all, this is unacceptable. So the basic issue is that, right, the background issue, it has always been there. In fact, there have been several states which has enacted the anti-conversion law, and those laws have failed. I think I'm not very sure about the year. Tamil Nadu also had a anti-conversion law. I think it was between 91 and 96. Tamil Nadu also had anti-conversion law, and that law was a failure. It faced public wrath. Madam Jayalalitha was the chief minister and AIADMK was in power. She enacted the law, and in the subsequent Lok Sabha elections, AIADMK lost all the 39 seats in Tamil Nadu and Pondicherry, for one seat in Pondicherry, which showed very clearly that the people are not ready to accept this anti-conversion law and all, and therefore the law was withdrawn. So there were several cases. So go through this, and also Article 25 to 28. Fine. Then comes the next issue. Now this issue, qualification of the governor. This is one sensitive issue. See here, forget about who is the person involved and all. Now, see, this can be an issue that is important for your mains as well. So you forget about the name of the person here, who is appointed and all those. That is not important. What is more important is, what is the importance of office of the governor, and what are the qualifications of the office of the governor? That's an important question. Okay. இது என்ன கான்ட்ரவர்சி அப்படின்னா, when it comes to appointment of the governor of a state, see, office of the governor had always been a controversy with respect to the federal arrangement, right? Many a time, many state chief ministers have regarded the appointment of governor to be something that is affecting the federal arrangement, and they had always wanted the office of the governor to be kept away from the controversy. But unfortunately, this has not been possible, and office of governor had always been a bone of contention between the states and the center. When it comes to the appointment of governor, how should the governor be appointed was a question. But how do you want the governor to be appointed? As far as the qualification is concerned, the Constitution of India is very generic. It says to be appointed as a governor, one has to be a citizen of India, completed 35 years. That's all. He must not be a member of state legislature or parliament. And in case, this is a prelims question, mind it, this statement is a prelims question. Does the Constitution of India bar any person who is a member of state legislature or member of parliament being appointed as governor? It doesn't bar. The Constitution does not prohibit a member of parliament or member of state legislature from being appointed as a governor. A member of parliament or member of state legislature can be appointed as a governor, but once he enters upon the office of the governor, his seat in the legislature, the state legislature or in the parliament will be deemed to have been vacated. So this was already asked in the prelims when it comes to qualification of the governor. So far so good, forget about it. Here, what are the other issues involved in the appointment of governors? Why do we have an appointed governor and not a elected governor? If the governor is going to play the same role as the president is playing in the union government, why do we not have an elected governor like that of the president, but we are having only the appointed governor? That has already been asked in the mains, and there are reasons. Now, when it comes to the importance of the office of the governor, see, basically this is the most important thing even today. There have been always issues with respect to the office of the governor, and in case you can even very well see the government of Tamil Nadu. When it comes to government of Tamil Nadu and former chief ministers of Tamil Nadu have always been, for instance, the DMK, the Dravidian political parties have always been they have taken a stand against the governor, office of the governor. They said the governor is an appendage. We don't need a governor. That's how it is. However, the office of the governor is very, very important because even the Sarkaria Commission, which was appointed to go through the issues of the center-state relations, had highlighted the importance of the office and has clearly highlighted the importance of the office and has not recommended for the abolition of the office. But they have clearly accepted the issues in the appointment of the governor and the relationship between government and the state government, and they have made some recommendations. See, office of the governor is important because he plays a bridge between the union and the state. See, once it was asked in the mains, the governor, the main issue of the office of the governor, concerning the office of the governor, is because the governor wears two hats. The governor wears two hats because he is at the same time the head of the state, executive head of the state, but also the representative of the union in the states. These are the two hats. Now, this is a problem. Which hat he is actually wearing? He has to wear the two hats in an appropriate time, and when he wears a particular hat will depend upon the political maturity, statesmanship, and the adroitly of the person who is appointed as governor. But unfortunately, this has always ended up in a kind of a issue. So he is to act as a bridge between union and state, and he has to uphold the federation. He is not supposed to act only as a representative of the union government and turn the federation into a unitary system. Instead, he has to act as a facilitator of the federation. He has to assist the state government through his statesmanship, his visionary, right? His visions, his political experience and maturity, rather than involving in active politics. Unfortunately, there have been several governors, and for your contemporary, to take the contemporary examples, the governor of Tamil Nadu, the governor of Telangana, the Delhi governor, what they are playing? So they are into active politics. Now, coming to this issue, the Sarkaria Commission had clearly recommended that the gubernatorial office shall not become the parking lot for spent forces of the polity and a reward for loyalty. Meaning, Sarkaria Commission has recommended that the government of India, the union government, shall not use the office of the governor as a reward to the loyal bureaucrats or to park the political spent forces. Okay, politically they cannot be very active. Politically they cannot be, they are no more useful in politics. You cannot do that. But unfortunately, that repeatedly takes place. More importantly, can the judges of Supreme Court and High Courts, particularly the judges of Supreme Court and the Chief Justice of India, can they be appointed as governor? See, this is now becoming, Justice Sadasivam was the first Chief Justice of India who was appointed governor immediately after his retirement as Chief Justice. Now, this brings down both the offices. The independence with which the judge could have operated while he was sitting as judge and delivering judgments, and the independence with which he will operate while he is appointed as a governor of a state, both are under question. All right, so here in this case, focus on independence of the judges of Supreme Court. What are all the barring after retirement, what they are not supposed to do? Focus on that. Then qualification to the office of the governor, focus on that, and conditions of office of the governor. These for the prelims, and the issue for the mains. If not in the prelims, this issue can be asked in the mains. When it comes to mains, it can be asked both in constitution paper or governance. In fact, it can also be asked in ethics, because these issues are more moral in nature rather than constitutional in nature. All right. Rest we shall discuss tomorrow.